Thank you. This is the Board of the Chiropractic Examiners. This Licensing and Continuing Education Committee meeting is being held via teleconference under the Governor's Executive Order N-29-20. The date is June 17th, 2021. The time is 10 o'clock a.m. The members of the public that are listening and would like to provide public comment by telephone will be limited to 2 minutes unless, at the discretion of the board, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. The board's paramount responsibility is to protect the health, welfare, and the safety of the public through licensure, education, and enforcement in chiropractic care. Please be aware this meeting is being audio recorded. Please turn off or silence your cell phones. We will now take the roll of the committee. Dr. Paris, would you kindly take the roll?
Yes, thank you. Dr. Deion McLean.
Present.
Dr. Lawrence Adams.
Present.
And Dr. David Paris present. We have a quorum.
Thank you, Dr. Paris. Moving on to item number 2 on the agenda, approval of the May 7th, 2021 meeting minutes. Do I have a motion?
Motion to approve.
I'll second that.
Okay, Dr. Adams. Discussion? Is there any discussion? I just have one point of clarification, yes, I'd like a little bit of clarification. On page 3, underneath the second paragraph, it says that Dr. McLean was concerned about creating a list as it would hem in the creativity of providers. I'm not sure about that language there, and if that was the way that it was articulated, I can be corrected, but can you tell me if that's a typo or if that was the way it was articulated?
Hi, Dr. McLean. Natalie drafted those minutes, and I know she's very accurate. I didn't go back and check the recording to see if that was the exact wording, but we can do that. But we would have to do that after the meeting. I can't verify what was actually said at this point.
Okay. Therefore, Mr. Knotes, can we still vote on this?
Dr. McLean, we certainly could, but that would constitute approval of the minutes. The other option would be to defer this item to the next committee meeting and look at those minutes after that's been verified.
Let's go ahead and defer this item to the next committee meeting then, just to get some clarification and make sure that there's accuracy there.
If we need a motion, I would make a motion to defer approval.
I don't think you do. There's a motion on the floor, but if the maker and the second are amenable to withdrawing that, I think that can be done by the.
I would like to withdraw my motion to approve.
Thank you, Dr. Paris. That being said, we will move that agenda item after clarification to be held or to be voted upon at the next meeting. Thank you. The next agenda
Dr.
item.
McLean, I'm sorry. Can you
sorry,
just
public
I
comment.
wasn't. Can you just? This is Robert. I
Okay.
just, where exactly was that verbiage?
On page 3, under the second paragraph, it's just one line. It says, Dr. McLean, it's right before Dr. Adams joined the meeting.
Okay, I see it.
You
Gotcha.
see it?
Thank you.
Okay, so
Yeah.
If you can just check that for me.
Okay, thank you.
Do we need to take public comment on this since we're deferring it, Mr. Knotes?
What we do, since it is an item on the agenda.
Okay, then I'd like to ask the moderator if you would kindly open it up for public comment on the minutes from, or the agenda item number 2.
This is the moderator, and at the direction of the committee, I have opened the Q&A panel. For reference, being displayed on your screen are instructions on how to request public comment. As indicated, all commenters will be provided 2 minutes and given a 15-second warning. I will pause momentarily to allow individuals time to access this feature. At this time, we have received no requests. Would you like me to close this feature?
Yes, thank you very much.
You're welcome. Feature's closed.
Moving on to agenda item number 3, public comment for items not on the agenda. The committee may not discuss or take action on any matter raised during this public comment section that is not included on the agenda currently, except whether to decide to place it on any future agenda items, Public comments are encouraged. However, if time constraints mandate, comments may be limited at the discretion of the chair. As stated previously, we will limit the public comments to 2 minutes, and they will not be deferred to any other public member. As always, we ask that meaningful comments and input is always welcome. However, anything outside of that, we ask you to refrain from at this time because it is not appropriate. Moderator, will you please open up for public comment, please?
Certainly. This is the moderator, and at the direction of the committee, I have opened the Q&A panel. Currently displayed on your screen are instructions on how to request public comment. You simply click on the question mark within the square located in the lower right-hand portion of your screen and type, "I would like to make a comment." All comments will be addressed in the order they are received. You will be provided 2 minutes and given a 15-second warning. I will now pause momentarily to allow individuals time to access this feature. At this time, we have not received any requests. Would you like me to close this feature? Madam Chair, would you like me to close this feature? We have not received any requests.
I apologize. Yes, please.
Feature has been closed.
Moving on to agenda item number 4, review, discussion, and possible action to Article 6, continuing education, sections 363.1 through 3666, pardon me. The Licensing and Continuing Education Committee will review and discuss the proposed changes to these articles. The changes have been put forth in writing here by the staff, and beginning with section 363.1, distance learning of courses. Distance learning education shall be considered as asynchronous learning offered on demand through the internet. This section, basically, we were going through just the parameters of distance learning and measures that should be put in place when looking at distance learning. I open it up for discussion with the committee members. If you have any questions or input here.
I had a question about section 363.2 under A1.
If we could just, I'm sorry, Dr. Paris, if we can just go section by section, so if there's no other comments or on 363.1 first.
Was it Just real quick, we're talking about the synchronous versus asynchronous. Is that what you're referring to? I'm
No,
trying to get my
we're talking about the
trying to get
entire
my
distance
notes.
learning section here. So it's not just that. We're talking about the appropriate level of technology required, the security measures that to protect the learner's identity, timekeeping, etc.
Okay. I'm just trying to get my notes pulled up here.
Okay, so while you're doing that, I just have one question or comment. Maybe Robert or Amanda or Dixie might want to give me a little feedback here regarding 363.1, letter D, timekeeping mechanisms to confirm licensees' participation and completion of the course. Did we also, one of the areas that I know that was previously mentioned was periodic testing to ensure the validity and integrity of the participation. Is that already assumed there? Is there something that we could maybe add additionally to the language, or the other board members, your input regarding that?
That periodic testing, from my recollection, was specific to the synchronous training, the live synchronous, so that there was confirmation that the person was continuing to stay logged in during the course. Or at least was there at their computer, so they don't know when when the instructor, again, this would be live, they don't know when the instructor is going to say, okay, we're going to do a quick quiz. This would be internet-based distance training, not live. So this is something that somebody could take on demand at any time. And I don't believe there was ever a discussion about requiring intermittent quizzes, because
You're right.
really, yeah.
You're right,
So,
Robert. I had that in the, that was in another part of my notes. I'm sorry, Robert. You're absolutely right there.
okay, so yes, any other questions related to that?
Not for me. Dr. Paris, Dr. Adams on 363.1. I'm sorry, I keep saying points too soon.
Nothing for me.
Okay, so we can move on to 363.2. Dr. Paris, I know that you had some questions here. So
I just had a comment regarding under A1, and then actually this continues on because it's just a clarification about the language we're using. So it's also under A2, and it's also under 363.3, number 1. But I guess anywhere that might appear is that it reads the instructor has been convicted of a crime substantially related to the activities of a provider or licensee. And I was wondering if that, if it might be better language to have that say the instructor or continuing education provider. Because I think we had clarified previously in discussions the difference between those roles. I didn't know if that was valuable.
I agree and concur. I do recall us discussing that. And I think that that's a good inclusion.
Yeah, I think it was when we were discussing a PACE or had a presentation by them that we were asking some questions of them as to how they vet. And so we had some further discussion back then on, those kind of separate roles and how the CE provider is not necessarily always the actual instructor, or one CE provider might have multiple instructors, etc. So I don't know if we need a motion to have, or just to more discussion on maybe having that included in that language, or maybe some feedback from staff too on that.
I don't have the full reg language in front of me. I'm gonna have to look that up real quick. But this is specific to course cause for withdrawal. Then that should be withdrawal of approval. And because then they're also on 363.3, it's the same thing, but that's for denial for a course. So there's there's a separate section for provider approval and the withdrawal of approval. And so that would be addressed there, not in this. This is specific to the course.
Okay. I mean, would it hurt us to have that language be okay?
Included in both areas.
I see the nuance, but
right.
I'm not
I hear
not
what you're
feeling
saying.
like that's, yeah.
Would it be detrimental for us to add the language in both areas? Just like Dr. Paris, we understand the nuance, but would it be problematic if we added it here as well?
I don't believe so. And in looking back, sorry, just one second. I'm reading as I'm talking, but actually, for provider cause for denial and cause for withdrawal, we don't mention that. And it may be because I know we've had discussions before about the fact that providers often aren't licensees, and oftentimes maybe like a corporation or a larger entity. It could be a school. So then it's like with schools, I don't know who would be like, say, if the CE coordinator for a school was, and they're listed as the contact person, if they were convicted of a crime, and would we withdraw approval for the school? I think there's potential problems we would run into with that. So I'm not disagreeing. I mean, I think we should be able to, if we have concerns about the moral fitness of a provider, we would want to be able to do something about it. But again, we're not dealing with one person. It's not like an instructor who's teaching a chiropractic course, or like, say, if it was an attorney who was teaching a law and ethics course, we wouldn't want a disbarred or a convicted attorney teaching the ethics course. But even with those, there's a little bit of a problem because we can't get criminal background information on those, so we would have to rely on them self-reporting. So, and that's something that would have to be the responsibility of the provider to monitor those things for their employees, and then report it to the board. So all of this, it gets, when we're not dealing with somebody who's a chiropractic licensee, the whole issue of convictions gets a little bit murky because we don't have access to that information.
Thanks,
But
Robert.
in the instance that we are dealing with, understanding that those are, and I want to say outliers, and use that kind of loosely, what other, would it not be beneficial to put it in there to cover those that we could have recourse with, or that we could
I would have to defer to legal counsel on that. It's just that I equate this to the chiropractic colleges and school approvals. We approve the schools, but we don't have any equivalent language, and I don't believe there's ever been an instance where we've withdrawn approval for a school because somebody affiliated with the school was convicted of a crime. I don't know if the schools have measures in place to address if they have faculty that's convicted, but that's something that we wouldn't likely know unless the faculty was licensed by us, and then we would be disciplining the licensee, not the teacher. So it gets a little bit confusing when we try to regulate the law violations by people who we don't have jurisdiction over.
So
Well,
Robert,
My understanding is, we're talking about the provider here, and then also the potential of an instructor that would be teaching for a provider?
Yeah, this section that we're talking about right now is specific to course approval, and right now it specifically says instructor. It doesn't address
Right.
provider, and
So- So we put the burden on the providers at this point, and that even PACE does that, puts the burden on the provider to make sure that he's vetting his instructors. Couldn't we put language in there that would say that, because you're right, we can't, per se, find that information out. We'd have to hope that it was self-reported, but can we put in there something that says, if it comes to the attention of the board or board staff that there has been something like that's grounds for denial or withdrawal?
I think we've had issues in the past when we've discussed this, because essentially you would be holding chiropractors, like if they're a provider or an instructor, you would be holding them to a higher standard in our CE regs than you would people that we don't regulate. And I don't think that would pass through OAL.
yeah, it's not a level playing field. And the other thing to consider, and Michael, correct me if I'm wrong here, but if a provider was convicted of something, although right now the language doesn't address convictions of providers, but if the provider is convicted of something, or for whatever reason we withdraw provider approval, then the courses that are offered by that provider would then no longer be approved. If they're not an approved provider, we wouldn't recognize any courses they're teaching from the point that we withdraw approval of the provider.
so it doesn't, maybe I'm misunderstanding, but it doesn't fully make sense to me that we would be holding licensees to a higher standard. I mean, number one, I think that's our role. And I think, as you just stated, that's really the only thing that can be inclusive in our regulations would be licensees. So, I mean, de facto, we would be holding licensees to a standard, but only with the acknowledgement that we don't control or have effect on any other unlicensed individuals. So I don't know how OAL would interpret that as, in other words, to me, I think forward thinking that to say that we couldn't prevent those convicted of a crime substantially related to the activities of a provider or licensee, it just doesn't, that's not making sense to me. So,
Well,
am I missing something there?
I don't know.
I concur.
Well, the nuance is that, yeah, there's nothing preventing us, and actually we wouldn't ignore if we're notified, because all of our licensees are fingerprinted, and so if we receive notification of an arrest or conviction of a licensee, we would open an investigation into that, and if it is substantially related, we would potentially discipline the chiropractic license. But now, so that would happen regardless of whether they're a CE instructor or provider. But if you're looking at the realm of instructors and providers, if you're a licensee and we take away your instructor or provider approval because we know that you were convicted of a crime, but if you're not one of our licensees and you do the same crime or a more egregious crime, we would likely never know and not be able to do anything. So it does create a separate standard for this same group of people. And it doesn't prevent not having that authority here doesn't prevent us from disciplining our licensees. But but if we're looking at the same group of regulated professionals and we're holding them to a different standard, that could be problematic. I can't say for sure, but OAL they may have concerns about the legality of that.
My suggestion was not, and I know there's other discussions kind of oblique to this as to how would we know or how would we find out, but that's not my only suggestion was that we add maybe language that identifies both instructors and duly licensed instructors or CE providers as underneath this regulatory language.
Yeah,
That way we can capture, because it seems also odd, Robert, too, that it's a course cause for withdrawal of a course. And I think really if we're capturing the bigger umbrella of, I think sometimes CE providers can also be instructors. So that would be the biggest group versus instructors may not be CE providers. So an instructor may not ever submit a course.
Right.
They may just teach it.
Yeah.
And so it seems to me like we're capturing the wrong side here, like if anything, we should first and foremost in regulations that are directed at courses, we should be identifying, the CE providers versus the instructors. My preference would be that we identify both if there are licensees.
I agree.
And that's all I'm concerned about, and it
Can't
can
we
be
just-
So
self-reported.
maybe we can distinguish that, Robert, that in some manner instructors and or continuing ed providers that are licensees.
Yes. I think that captures it. Why can't we just put in that same paragraph, just add and or providers? That captures both sides. I mean, how could that be considered? Because David makes a great point. There are CE providers that also are instructors of courses that they submit. And then there are those that are just instructors, and there are those that are just CE providers. If we don't put CE provider in this aspect, you could technically have a CE provider that has been convicted, who submits courses for instructors, and he never teaches, but he himself has been disciplined by the board, and I don't think that's in the spirit of this section either. So I concur that we just add instructor and or providers
That are licensee.
Okay,
Yeah,
we're
well, I
going
think
to
it's-
have to, that's fine. I mean, we can do that. It's, again, I don't know the answer to the legality question, but we can do that. But then we're going to have to go back to section 362 and 362.2 and 362.3 and 4. So we're going to have to go back to all of those and put in the provision because right now we have a separate section for providers that the board or the committee did not decide needed to include convictions. And I know we've had these discussions while we were going through them, and that wasn't amended into the language. So I'd have to go back and look through the minutes and stuff. I don't recall.
Are those related to withdrawal or denial?
Yeah, they're withdrawal and denial. So those for providers, because providers and courses are separate. Courses are submitted by providers. So
Right.
so yes, we can deny a course if the instructor, because the provider has to let us know who the instructors are. But it's really, I mean, unless they do report it to us. I mean, because I don't even know if within our current system, because the tracking is manual, I don't know if we would be able to cross-reference. Like if we know that if one of our licensees, we get notification that they've been convicted, we don't necessarily know that they're a CE provider because we have a master list of the instructors. We don't keep a database of all of the providers because some instructors could have 100 providers. I mean, 100. Some providers could have 100 instructors, and we we look at the CVs for those instructors to see that they're qualified to teach the course. But those instructors aren't submitting an application to us for approval. It's the provider. So we don't, we're not really even regulating the instructor. We're just looking to see that, if someone's teaching a chiropractic course, that they're a chiropractor. Or if they're teaching, a health, like a nutrition course, that they have some academic or professional background that would qualify them to teach a nutrition course. And so that's what we're looking for with the instructors. And otherwise, we don't have detailed information about the instructor. We don't have, and except unless it's on their CV, we don't know their address and phone number and social security number and all that kind of thing. We don't currently collect that information, and that would be a whole new realm of regulatory authority if we started regulating the instructors. Because right now we're kind of holding the provider responsible for ensuring that their instructors are appropriate to teach. And so we could put in the provider responsibilities, if it's not already there, to ensure that the instructor has appropriate training, and that they haven't been arrested or convicted for crimes that would be
I think we
related
should
to.
absolutely include that.
Yeah.
We should absolutely include that in the provider responsibility if it's not there currently
Okay,
in the language of that.
Okay, we'll
So where we're at on this is, it sounds like we need to gather some more information and revisit this. That's what it sounds like to me. Is that what I'm hearing, Robert?
I suppose, again, we've already discussed this at length, and that wasn't put in when we were discussing providers. There was no discussion by the committee. I mean, there was no, the committee decided that wasn't part of, that wasn't something they were going to put in here about providers. So now we're going back. It's going to require more research, and because this level of scrutiny of providers and instructors is creating a big additional workload, and so we're going to have to go back and not only, I mean, we can certainly put those things in our regs, but I don't know that we're going to have the teeth to be able to track and enforce it. So those are the things we need to consider.
Even with the new system, and with I know that PACE only does a deeper dive once there is a complaint, but even with the integration of that and the new IT that's coming down the line here, you're saying we still may not have that ability?
Amanda just reminded me that there's an instructor attestation form. So, because, I mean, we're talking about CE providers across the country, and instructors. I mean, so there's potentially thousands. We potentially have more CE instructors than we have licensees, chiropractic licensees. Providers, I think we have a couple of hundred. Instructors, depending on the size of the provider, each provider could have dozens or hundreds of instructors working for them. Some of these instructors may only teach occasionally, some may teach on a regular basis. Sometimes, right now, I don't know if there's anything that prevents them, if the instructor gets sick on the day of the course, if there's anything that prevents them from substituting with somebody that we may not have vetted. And so, are we going to require them to cancel the course if they have to change the instructor? And, we may, or if they just change the instructor and don't tell us, we may or may not ever find out. I mean, there's a lot of things. We're getting to the point of micromanagement of this, and we just don't have the bandwidth to do that. It's I'm not in disagreement with the intent here. I think it's I want to ensure the quality, but if we're talking about a lot of CE is offered online, and it was filmed or videotaped, or it may not even be so the instructor isn't necessarily coming into contact with the attendees, and the course may have been developed, and that everything put together prior to us approving it. So then if the instructor gets arrested afterwards, are we going to then withdraw approval for that course that's already done and we've already, people have already been taking, does it make that course any less valid? I mean, there's a lot of questions, and I can't help going in all these different directions because that's what I do. I'm looking at all of the policy concerns here, and there are many. And so this isn't a simple yes or no question, and it would and ultimately there's it raises legal questions, questions of equity, and those are things that could get it denied through OAL.
Well, I think Madam Chairman's statement early on is that this is probably a rare event if it does happen, because I think most of the people, like you just said, Amanda said, there's an attestation. I think my only thought was, and maybe that's what Dave brought it up, is that the potential for, since it doesn't specifically say provider in the language, that a provider could be either on probation or have been disciplined by the board, and then just be having instructors do the teaching, which I guess in that sense, you could say, well, he's not the one doing the hands-on, and so does that mitigate, or does that diminish the information if it is an approved course? So I get where you're coming from. I think we beat this pretty good, but I think that's where I was coming from after David brought it up, is that if it doesn't expressly say provider, could that person potentially work around these regs and still be earning an income from chiropractic when they are maybe not of the moral turpitude that we would like?
So
I think what we need to do, though, if we're going to put requirements and responsibilities on anybody, it should be on the provider, not on the instructor. We're getting too far removed if we try to regulate the potentially thousands of instructors that are out there across the country, and some live and in person, some only online, some may just be a paper course, and there's no involvement with the individual. So I think we just need to hold the provider responsible for the content, quality, and morality, if you will, or legality of everything having to do with the courses that they're offering. Because again, it's not the instructor that's submitting the course for approval, it's the provider.
So Dave, what would be your suggestion, or
Well, my intent was only that when I read it, I felt like that small addition was strengthening the language. And I hear what Robert's saying. I kind of think that strengthening the language actually does put more of the onus on the CE provider, because that's what we'd be adding here. But
Hey, Dave,
but I understand.
Dave, real quick, let me interrupt, because I just was looking at the bottom of C63. Robert, did you look at the bottom of 363? And Natalie did include in number 4, any material misrepresentation of fact or any documents required to be submitted to the board by the instructor or provider. So she did put or provider on that, and I think that's kind of what we're asking here. And since it's there in that language, could it just be potentially that maybe Natalie forgot to put or provider in the other spots?
I'm sorry, where are you
it.
looking?
So if you look at C 363.3, continuing education course cause for denial, which is what we're kind of talking about, either
we're talking about point number 1 there, Robert, and what Dr. Adams is referring to is point number 4 in that same section.
Yeah, so there's multiple times there it says, like point 1 says instructor has been convicted of a crime related to the activities of a provider or licensee. I mean, she's kind of using provider, licensee, instructor kind of interchangeably there. In a couple of spots she does put like it, and if you look at point 4 at the bottom of 363.3, she does say any material misrepresentation. And so in fact that kind of that kind of encompasses what we're saying is
I
number
wouldn't
4.
say that she's using them interchangeably. Let's just
Yeah.
be clear on
Yeah.
that. She
Yeah.
is using them as in addition to each other. So she's
Yes.
being inclusive, not
Yep.
interchangeable.
Which is, I think, kind of the spirit of what you were talking about, David, that we include it.
Yeah, I mean, I think that was my only, that was all I was wondering about, was if there was gonna, but now that I'm looking at, it's written the way that I think would be appropriate everywhere under 363.2 number 4, as you pointed out, and also 363.3 number 4, as you pointed out.
Yeah.
And I don't know if it's a simple solution to make that language just consistent.
The,
I don't know why we would have to go back.
The only difference between 1 and 4, the big difference is 1 is talking about convictions, and the other one is talking about information that they're required to submit, materials and information. And so if they're submitting false information, so it's the conviction thing that's a big can of worms, and we can put that in. I say
So
we just
let me
put that
ask.
in.
Yeah. So let me ask, in that information that they are submitting, is in that or that attestation, is there a question regarding conviction? Because if there is, then that's covered. It covers it.
Yeah.
Yeah. I don't know that legally we can ask, to be honest. I mean, it's getting more and more. We can't even ask licensees anymore with new laws that are coming out. We're not going to be able to ask licensees if they've been convicted, because we get fingerprints because they're live scanned. And so the legislature is saying, well, why are you get that information? Why should they have to provide it? And so it's this is becoming more of a contentious issue in the bigger realm, and it's for licensees. And now we're getting removed from licensees who are treating patients into this this kind of related industry that we're regulating or semi-regulating, and to be able to enforce discipline based on convictions. It just and I don't disagree with anything you're saying, and I'm not trying to complicate things, trust me. But it's a big can of worms, and I'm concerned. I just want the board or the committee to know that this could come back to create problems for us when we submit this to OAL. We may have to withdraw it and take some of this stuff out, because I really question our legal authority to be able to enforce some of this when it's related to convictions.
So that we can so that we can bring this all back. I think that we've kind of, like you said, you've presented a lot of information here on the potentials and possibilities, but so that we can bring it all back to the initial question of whether or not it would be prudent for us to add it there. With all that information that has been given, Dave, I have one other question. The question that I just asked about the attestation, and was the main thing. If we're not able to ask that question in the attestation, then it's not covered there. That was my hope. But to bring it back to your original question, Dave, are you still concerned enough that we should continue to look at the potential here, or does the answer in number 4 satisfy you?
Something else going on, you might.
Well, I think the language is adequate.
Have them scheduled.
As
Someone,
I was
hold
trying to
on.
strengthen it.
Someone's mic is on and we hear a lot of noise in the background. Can you turn your mic off if you're not speaking?
I think that may be coming from Dave when he has his mic on when he's talking.
Yeah, sorry. I think the language is adequate as it's written. I was just trying to, as I read through this, I just was trying to strengthen, and maybe I felt like it was going to be more consistent. That's all. So I'm okay with it as is. That was the whole point. That's why it was just a kind of a friendly suggestion and something I thought we might discuss.
If the committee wants to pursue that, I think it would be prudent to request a legal opinion about when we're getting removed from licensees who we have statutory authority.
But Robert, we're not. But wait, let me clarify, because what I said initially was that we're not. I understand. I was hoping that we would frame the language to reflect that we're always referring to instructors or CE providers that are licensees as the only, you know, the only people that we regulate. I mean, that's all we can control. I'm not trying to get out of bounds on like, oh, we should control the world and the United States and anybody that submits. I was just trying to say, in our sphere of control are the licensees that apply for this, and the instructors and CE providers. And I was hoping we could have language that reflected, you know, both of them in these regulations that are licensees. To be clear, I am not referring to anybody else that is not under our jurisdiction, you know, only regulating licensees who are our instructors and CE providers. I don't really see how that creates a burden, or how there's some discriminatory impression against other against our licensees versus other CE providers. We simply have no control. We acknowledge that. But if we could rule the world that way, we would probably say, hey, we would like that to apply to everybody. Unfortunately, I realize the reality there. And so I'm trying to kind of stay in the bounds of what our role is and just say, can we have both of those identified? I thought it would just be consistent, but I'm not hung up on it in any way. And I think the language would suffice as is. It was kind of a friendly suggestion. And I do apologize for not kind of recognizing that earlier, because I know I've been on the very calls that you mentioned where we, you know, we have gone over this. And sometimes I think, you know, there's just layers, and I kind of go through it in layers. And so that's, you know, that's my excuse for not catching it sooner or recommending it sooner.
It is overwhelming, and you know, you know, and that's fine. I mean, I'm not objecting to what you want to do. I'm just raising the potential problems we may have, and you know, the problem that we'll need to address, and you know, and we can just move forward and see if OAL calls us on it. But if I'm a California licensee and I've been arrested, or if my license was disciplined by the board, I could be told you can't be a provider or you can't be an instructor. But somebody in Nevada who's licensed in Nevada and who was, you know, arrested, or if their license was disciplined, we would allow them to, you know, so you could have two people who are guilty of the same crime, and we would be accepting one as a provider or an instructor, and then we would be not accepting the ones that that we already regulate. So it just it creates a separate standard, and that's my and I'm not saying that we shouldn't do that, but it just, that could be problematic for us in getting approval for this.
So can I ask this question then, Robert? And similarly, this was one of the questions that I had in this same section, 3.363.2. It says in the bullet point number 2, where it talks about jurisdiction, my question was, why could we add any jurisdiction and not just say by the jurisdiction the provider or applicant holds their license? So you're saying that we cannot do that if they have been disciplined in any other jurisdiction?
Well, we would have to know about anything that happens to one of our licensees, because we have, you know, we have LiveScan and we get notified. So and if, you know, I don't think we would be able to get authority to require people to disclose a conviction, and so we wouldn't know about somebody who had issues in another state. You know, if it's if the provider is headquartered in Florida and they're employing instructors that are based in Florida, who may or may not be licensed, may or may not be convicted of crimes, we don't know any of that. We really don't have the ability or the resources to find all of that out. But just because it's, you know, low-hanging fruit
We-
for us. Our licensees,
Right.
we get notified right away if they've been arrested. So then, and certainly that this doesn't have anything to do with our authority to discipline that licensee. But then when we're talking about a separate regulatory scheme that we have for CE, then we're holding the California licensee to a different standard than we are, any other instructor or provider who doesn't happen to be regulated by us already.
Well,
So
real
it
quick,
just-
Robert, real
Yeah.
quick, maybe I'm reading this wrong, but I read 363.3, number 2, that if they are an instructor and their license has been revoked in their state or has been disciplined in their state, then I'm getting this as that could be grounds for our board to deny them providing continuing education. That's how I read that. By the
Just
board
one
or
second, let
the
me find my place
jurisdiction
here.
the provider or applicant holds their license. I mean, that's if you use the Nevada, if a guy from Nevada is a instructor or continuing education provider, and he's had his license revoked, suspended, placed on probation, voluntarily surrendered, or otherwise disciplined by the board or by the jurisdiction the provider applicant holds their license. I think that is pretty clear that is grounds for denial for them to be a provider of or instructor for continuing education if that's the case.
Yeah, you're, and I apologize.
Okay.
I
mean, I think that's pretty clear. So,
well,
and
yeah.
in
So
fact,
that's so. Yeah.
I mean,
So
that's that's got teeth.
Yeah, I mean that true. And so so if they've been again, I mean we're relying on self-disclosure, but also and that's I'm assuming I trying to go back and forth between all these documents, but I'm assuming we probably state that in the provider requirements that because ultimately it's the provider's responsibility to ensure that their instructors meet any requirements we may have. And
Okay,
just like with,
so can
just like with accrediting colleges, we trust the colleges to regulate their employees.
Understood.
And so if we put a requirement in there, then we would need the provider to disclose that information to us because we're not dealing directly with the instructor. We're just being provided
Understood.
Yeah,
Understood.
My feeling is that I would just say this is my final thought on this. I think the language in here that's been drafted it meets my concerns, and I think David summed it up in that it was more of just consistency. But I see enough in here that says I think we got sufficient teeth. That if it comes to our attention in the rare occasion that it does, then I think we got the rules, we got the teeth here to act.
Okay, so then let's move on. As stated, with the language that's there currently, Robert, we will say that will be sufficient in the way that it is, and in both areas of jurisdiction. You're right. After rereading that, the addition of the "or" in there clarifies that, as well as Dr. Paris has already stated that he's satisfied with that, so we can move on. We don't need to continue to lament over that. So that being said, moving on to 363.4. In this language, in this area, continuing education course appeal process. Wait, one other thing that I wanted to suggest, and I don't know if it would probably be more prudent in 363.3. Previously, Dixie suggested a time frame for when they could reapply. And I didn't see that in there. Dixie, correct me if I'm wrong, if I missed it somewhere. I just wanted to make sure that we address that as well. If they are denied, that there should be a time frame to which they could reapply. Can you help me out there?
Sorry, I'm looking at the proposed language here under 363. 3.4B.
They're read to me that
Yeah,
it
so it
gave,
does not include that.
right. So shall we, are we able to include something? Because this has been discussed previously and I thought that we had decided that we wanted to.
I don't know that it should go under 363.3 because that's cause for denial.
Right.
Oh,
So
I was just looking at the language at 363.4. It said at the bottom there, executive officer shall reschedule the request no later than 180 days following receipt of the request. I'm not.
No, that's all about appeals.
that's for the hearing.
The hearings, and that has nothing to do with them reapplying.
So I think it should go under the appeal section and maybe under as a separate section C. That if a, well, actually, this is still under course. I think it's not included in course because it's primarily the provider that we're concerned about. It should be in the provider section, where if we didn't withdraw the providership, that they should not be allowed to apply to become a provider right after we deny them. So it should be under the provider language, not necessarily the course. Because
so do we not, I'm sorry to cut you off, Dixie. So do we not have any parameters? Because if I'm a provider or an instructor and I go through this appeals process and I still want to come back and resubmit my course, there's no parameters for us to say, okay, well, if
Well,
I vamp my course or whatever, address the issues, when can I come back and resubmit?
we allow them to resubmit at any time, and they're going to pay a fee whenever if we deny a course and then they want to resubmit a course, we will charge a fee. So if they're going to submit the exact same course application that we denied and they went through appeal and the board upheld our decision to deny, that would be a waste of their time and resources to continue and submit a course application with a fee that they know we're going to deny. So I don't think the problem lies there so much as it does with the provider themselves.
Okay, duly noted. So that will make sure that we have that added or adequately added in the provider section. Okay. Anyone else have
FYI,
anything there?
I'm looking back at the provisions related to providers, and we do not have a specified time period when they can reapply. But as Dixie pointed out, if we withdraw approval for cause of a provider and they reapply, and whatever reason we used to withdraw approval is still a factor, then we would continue to deny. So, but it probably would be a good idea to put
I think it would be prudent.
a time frame in there,
right.
So that, because yeah, I mean, because
I
if
think
somebody,
that would be prudent. If
so
we could just if we could do that, Robert, I think that would definitely be prudent. Especially since it's been in conversation, it looks like at least 2 or 3 different occasions.
okay,
Okay.
yeah, we'll look into that.
So I can just briefly apologize. So what would
You're
be
welcome,
the
Frank.
rationale for having the time frame versus just correcting the deficiency?
Well, if it's something related to the provider personally, like they were, if it's a deficiency, yeah, then they just need to correct the deficiency and they can reapply. if
Right.
we withdraw, and I have to look at, I'm getting a little disoriented because I'm going back to stuff that was in the past, but if I'd have to look at what the criteria for the provider, so cause for withdrawal would be material misrepresentation of a fact by a provider, failure to submit course roster, failure to administer business responsibilities. So the material misrepresentation of fact. So say we withdraw or deny because they misrepresented a fact. How long should we, make them wait? Because we're essentially disciplining them for lying. How long should we make them wait before they reapply? Can they just fix it and say, oh, okay, you caught me, I'm gonna tell the truth now and reapply?
Yeah,
I
understand.
Yeah, because
I
if
understand.
it's something like, yeah, they failed to do something that they were supposed to do, and we take action, then if they correct it, we can. So I guess if we the other thing, if we do withdraw or deny, we could state, but I think we would need authority. We could state you can reapply after X amount of time. So, but it may be situational. It may, some cases you
Right.
may think, okay, we want them to wait a year. In some cases, it may be a couple
Right.
of months or so. So
My concern, Robert, was just that if depending on the time frame, which I know we're not going to decide here today, but that for somebody who makes like an administrative or clerical error and they fix a deficiency, that having a time frame essentially beyond the time that they've corrected the error or the deficiency, for us, it becomes punitive in nature. So
yeah, true.
anyway, and I know you mentioned
And
discipline, and I'm wondering.
But and that's what I wanted to capture is maybe there needs to be the distinguishment, or could there be a distinguishment? Because I certainly don't want to penalize someone for a clerical error. However, for someone who misrepresents facts, I don't think that they should be able to just say, oh, oops, I lied, and here's my application again with the corrected information.
Yeah, understood, and I
True.
agree with you.
Since I've been involved in CE with this board, there's only been 2 times that we've actually withdrawn a providership. And it's not based on one, clerical mishap or an oversight or anything like that. It's a serious, it's like false or misleading information that they submit to us based on a CE course, or it's repeated offenses of the same issue. So we're not just, going to be denying providerships willy-nilly based on one little administrative error or something. So I just wanted to assure the board that that's not what we have been doing with our current regulations, and will not be proposing to do with the newly proposed regulations.
Agreed. And in 362.2, we have notice of violation for providers. And so, I mean, likely some kind of an error or, something they did incorrectly, we would notify them that they violated it, they fix it, there's no discipline. So denial or withdrawal of approval is going to be relatively rare. But if it's some, issue where we're concerned about their fitness to be a provider, then yeah, I don't know what the time frame would need to be to for them to wait to reapply.
So are we in agreement that we should add a time frame, and we can just staff can make a recommendation of that time frame given all of the plethora of information that you have, or what would you suggest here?
My suggestion is, I mean, I have complete confidence and trust in the decision making of the staff reviewing these, and as Dixie said, and I think efficiency wise, I think, and correct me if I'm wrong, but if there's a question or something that we need to discuss as a committee, or as a board concerning a provider, I believe we could put that on a committee agenda. And, you know, we could defer, could we, I don't know, could we defer that decision until it's discussed by the committee? And that kind of has the effect of, you know, delaying a provider being able to, you know, to be able to, you know, to actually do CE until we've actually had time to discuss it. I don't know if that's
I
reasonable.
think there's already inherent, I mean, in that, if the appeals process in itself is already a delay, that's already quasi punitive that, you know, if a course is denied and they appeal it, you know, they could be delayed up to 180 days or more. So
We're talking about providers now, because we're saying that that didn't apply to the course, Dr.
If I
Adams.
may, the provider sections aren't on the, you know, they're not the sections that are on the agenda to discuss today. I think what we need to do is bring back 362.2.
Point two,
Actually, no, let me see, 362.
point four. It looks like point
Well,
four.
no, I think we need to look at all of them because they, you know, they overlap. So 362.1 through 362.5. I think we need to bring those back. And what I would propose is considering putting something in here that would give the board discretion to specify a time when they do deny, to specify a time frame based on the circumstances when that person can reapply, or that provider. So, and we can discuss that at the future.
Sounds good.
Next meeting.
Yeah, I like that.
Sounds
Thank you,
good.
Robert.
I like that. Thanks, Robert.
Mhm.
That's how we'll handle that. So thank you, Dixie, for that information too, and for clarification on that that as well. So moving on to 364, exemptions and reductions of requirements, looking at who may qualify as for exemptions to the current standards or requirements in 361. The only question that I had here would be on letter E, notwithstanding section 361C, regarding continuing education courses due to physical disability. Should we include, or is it necessary to include temporary physical disability, or because as we read through that, it's basically stating that these are not, this is not meant for, this is meant as a temporary, and that they would have to reapply anyway. But should we include
That's
just
specified in the next. That's specified in the next subparagraph, E1.
Right, but should, under here, should we say temporary physical disabilities here to clarify?
I don't think
Instead
it's
of the-
necessary because it's a one-time deal, and then the next renewal period they would have to reapply for the.
Okay,
So yeah,
Okay.
so we wouldn't need that.
okay, I'm good with that. Then anyone else, anything in that section? Okay, nothing. So move on to 365, revoked licenses. Anyone have any? That's pretty straightforward, and the language looks straightforward.
I have one just discussion point, and I think the language is okay. So, but what I'm wondering is we have a. It seems like more so in the last few years we've moved to having actual testing done, or mandated some testing, whether it's you know, retaking the state licensing test, or EBAS testing, or we've even had discussions of, like, you know, part 4, et cetera, for reinstatement. And I'm wondering if we should include that, is if the verbiage, if that's necessary to include testing along with at the last line there where it says to complete such study or training. I don't know if that differentiation is important. It seems like it was missing when I read it, and that we might want to, as just a kind of improving on the technical language of that, to include that we can require them to actually test.
I don't think
It's the
you need
same
that
as study or
authority here.
training.
Oh,
Okay.
Sorry, Dr. Parris.
No,
I don't
that's
think
all.
we need that authority here because the board has the authority when they're considering a petitioner for reinstatement. The board has the authority to reinstate with terms, and you have complete discretion to decide what's appropriate at that time. So I don't think we need that here. And actually, now that I'm looking at this again, I question whether this should be in the part of the regs with CE. We should probably have something where, this should be under where we have the process for petitioning for reinstatement, or so this is something that should be there. It's it kind of fits here, but not really, because it's not about CE. It's about what you need to do to get your license back. So, but nonetheless, we don't need to give the board authority to impose testing or whatever upon reinstatement.
We're covered, you think, under our terms and
Correct.
okay, thank you.
Okay, moving on to 366, continuing education audits. I have a question on the third paragraph. At the bottom of the third paragraph, it says providers who provide false or inaccurate verification of a licensee's participation may lose their provider status for up to 10 days at the discretion of the executive officer. Should that include the board or the board? The review, because the review committee's ruling, it's coming from the review committee's ruling, it says, shall be the final order of the matter. Or is that just like,
I think this is alluding to the fact that the first
I'm sorry, where is this? I got.
that's okay. The third paragraph down, the second to the last sentence, you see where it says up to 10 years at the discretion of the EO?
I'm sorry, I'm completely, I got
366, 366,
Okay,
continuing
that's what I
education
need.
audits,
okay.
Page
I'm sorry.
5.
third paragraph.
I thought I didn't realize we had gone to the next one already.
Sorry, Robert.
Oh, no, that's okay. I just going back and forth between a lot of things. So, I
think it follows discipline, where the executive officer has the discretion to discipline somebody, but
they can
the
appeal.
person being disciplined has the right to appeal it, and then that appeal would go through the committee, and ultimately the committee is going to have the final say on the matter, just as you do with accusations and everything else.
Yeah.
Absolutely correct. So just like if we deny a course, like recently happened and they appealed it, their first step is to request an informal conference with the executive officer. If they're not satisfied, they can appeal to the board, and then the board would be able to make the final determination.
Okay.
Although that could take more than 10 days. So, oh no, 10 years. So,
10 years? I hope
yeah.
not more than 10 years.
Oh no, I was thinking it was 10 days. I thought, well, yeah, they might as well just wait. So, okay, yeah, so they can appeal to the board.
Okay, and then the last paragraph there, I think is great. I just have a question on, will we eventually be able to fill these out online? It's talking about requiring continuing ed providers to administer the post continuing ed evaluation form. Is that something that we will eventually, with our new IT systems, that they will be able to directly go to the website and do that?
Correct. They would either we could do it that way. We could have something set up, but I think it would be probably these are technical things that I'm not sure about, but have the provider have a portal for this form, the post-continuing evaluation form, and when the attendee takes that evaluation, they can submit it, and it would be sent directly to the board and to the provider, because either that or the provider would have to forward them to us. But we could require, as a condition of getting approval for that course, the licensee has to submit the evaluation form. So this way we ensure we get evaluation forms from all the licensees. That would be very helpful.
I like that. I like that. And I also like the ability for for it to be sent to both the provider and the board, especially when you're speaking of people and their fear of anonymity and being honest without repercussions. That kind of ensures that fact for a lot of folks, that, okay, well, if it's going directly to the board, they will know, and I don't have to be as concerned. And I think we mentioned that on the post-continuing ed eval form, that at the bottom, that if you wish to, you can submit it directly via email. But is that as prudent as having it go directly into our system? And I'm just talking about once we do get this other system going.
Yeah, I mean, certainly it's a possibility. I'm getting ahead of myself, though, because I don't know how technically possible that is, and I don't know if it'll be problematic requiring everybody to submit an evaluation. But at least we would then know that they were receiving the evaluation, and even if they just choose to not fill it all out, but they send it to us, at least we know they received it and it came to us. So those are details we would have to work out.
I think that particularly because I've been in situations where there needs to be a way to report and evaluate. I think that it's very important for all of these classes to be evaluated by the individual licensees. I think that's important information to get the perspectives, because there's so many out there that are not up to par, and we won't know if nobody's reporting it. So, anyone else, anything there?
I have, well, go ahead, David.
No, please, go ahead.
Well, I think having sat in on one of the meetings that were forwarded to us and listening in, that was a question that was brought up by some of the providers when they were discussing this. Is this going to be a requirement? Because a lot of the attendees at seminars, they click off, they're not, sticking around. So there was some feedback about, making this mandatory, or not, and how do you require that? How do you, because people are, people eat at food places
if people
all the
want
time.
their continuing ed credits, then they will do it. If that becomes a part of it, that's an easy fix of how to require it. It's a matter of, I understand from the provider perspective, I've listened to that as well. But I think that our position needs to be on protection and getting the information necessary to protect the public.
Okay, well, if I could just finish my thought. So listening in on there was feedback from the providers relative to the logistics of how that gets implemented. And then as far as the having been a provider, an instructor in CE, I think constructive feedback is always helpful. One of my concerns is, just like a lot of concerns that businesses have with Yelp reviews that, you know, what constitutes, you know, an appropriate, you know, suggestion or feedback or whatever. These, you know, some of the questions on here I see as being a little bit ambiguous, and also, you know, a lot of people take courses over and over again, so the information may not be new. So I think this form can be reworked a little bit, but I mean, I like the idea of it. I just think that some of the feedback from providers was pretty constructive about just the implementation of this, and making it mandatory upon them receiving their CEs. Seemed to be a little bit of pushback on that. So also, you know, how do you determine, I mean, people give feedback all the time. They may have tried some out, don't like it. What percentage, you know, if a person gives a bad review, just because they don't like a topic, you know, what percentage of bad reviews determine whether a course is good or bad or subpar, as you mentioned. So I think there's some things that need to be addressed there that are going to make this a little bit more appropriate. I for one am not big on people not signing their name to something. If they have a comment to make, I think they should be accountable for their comments. Obviously, they shouldn't be penalized for having a negative comment or negative review, but I think it's appropriate to for that someone is going to say something negative, or they should be able to sign their name to it and allow that to be addressed. That's my 2 cents.
Great. I think that when looking at these, we are asking questions about the competencies, and I think that that's where we will delineate whether or not it is frivolous information or frivolous response versus substantive response. That's what we're interested in, and that's why these seminars and them following what they're saying that they're going to be following is very important. I think that we need to be very cognizant about, and we need to have some discussion about the repetitive nature of people taking courses, because that reflects negatively in their true desire to utilize continuing ed in the fashion to which I think the continuing ed is put forth, in that continuing education is continuing to learn, and not just do something over and over again to check a box. I think that that's something that we should address, there should not be that ability to do that over and over and over again, an enormous amount of times, especially within the same cycle. That does not reflect on the nature of why continuing ed is required. So when you speak of that, I think that is less of the problem than, or less of a concern, or should be less of a concern. If you want to take something over and over again because it's a complex issue, that's one thing. If you want to take it over and over again just because you like it, that's fine. But understand that this is to evaluate and make sure that the courses that are out there are meeting the standards to which they need to meet in order to educate, and that's the priority, to educate the providers, and not just, again, not just check a box.
Just
that
some food for thought here, and there's a lot to process just on this one issue, but with 13,000 licensees and potentially 24 courses most of the 24 hours isn't going to be taken in 24 separate courses, but potentially somebody could take 24 courses. That's 312,000 evaluation forms. We don't have the bandwidth to be able to review all those. I don't know if we'll have a system that would be capable of analyzing those and providing us with feedback that in an aggregate form that we'd be able to use. So
I would hope that we would have a system that, I'm sorry, that would at least provide us with those forms that have a negative reflection of the courses, and or at the very minimum, when courses are audited, we could pull the evaluations or look at the evaluations as a part of that.
Yeah, potentially. I mean, right now we haven't even gotten in our new IT system. We haven't even gotten to the CE part, so I don't know what we're going to be capable of, and I don't know how soon we're going to be there. Just wanted to put that out there that and it's like it may be a thing where we may just have a requirement of the provider that they have to make this form electronically available to licensees. I mean, to attendees of their courses, and it can be sent directly to the board. So there's a number of ways. We'll have to think about it, and because there's a lot of unknowns right now. But it is potentially going to create a large volume of information that I don't know if we'll have the ability to process.
Well, Robert, was my next comment was what impact that would have on staff, because of a lot of the regulations that we're changing have the potential here, if we don't clarify and streamline some things relative to the competencies, that could be extremely time consuming for staff. And this, I think, would just be another layer of requirement there. If it were electronically where they could check a box and get that feedback, because then that could be very easily converted into, how many positives, how many negative reviews, or whatever, on a 1 to 5 scale type thing, would be a quick look at that, as opposed to this where it almost has to kind of be looked at each one individually.
Well, I think checking a box, again, is not, while it sounds good expeditiously, it's not giving the feedback necessary. So if you check the box at 1, there needs to be an explanation to go along with that. So just like you mentioned earlier, that people are not just being frivolous or nefarious and just they don't like the person teaching, so they're checking the box. That's not what we're looking for. So I think that while we don't know what the system is going to hold, these are all things that need to be asked while evaluating the system, or while the system is being put into place, because ultimately, as we are moving deeper and deeper into the technological era, we know that there are systems out there that can delineate a lot of information and give definitive reports based on numerous categories. And so that would be what we should frame it as, frame our investigation, or as you're meeting with the IT people, these are questions that we have. Will we be able to do these types of things so that we can form the appropriate forms? I do think that you have to walk a fine line. We have to be careful when we say, when we consider demanding people to put their name to certain things when it's going back to a provider, because people are afraid of punitive or for repercussions. A lot of times people are taking courses from providers they may or may not know or have taken in the past and want and or have some type of distant interaction or relationship with, and you don't want necessarily your name associated with that particular provider. With giving that particular provider information, and maybe that name should only be given to the board and not to the provider themselves, to prevent that. So those are just some other additional food for thought, things to put in the wheelhouse to pontificate over. Additionally, just at the bottom of this form, the wording there could read a little clearer, in my opinion, as well as item number 2, if we're asking if it met the continuing ed competencies, or if they were clear to you. If there's a no answer, at least having a line as asking why.
Well, I think that brings up another point. Sorry, David, you haven't spoken. I'll back off. Go ahead.
I just wanted to say that I think when we look at this, the CE evaluation forms, as Robert mentioned, the reality of being able to audit all these kind of as written and actually have somebody, unless the IT system somehow develops something where we can, have some cumulative data on each course or instructor, et cetera. But absent that, and when I look at this form, where there's some questions on here that make me wonder if this isn't some sort of like quality assurance that might be better for the providers to be doing on their own. Because my impression of the CE evaluation forms is, number one, that it serves as an attestation of the hours and the attendance, and that the course was, as advertised. In other words, they followed the syllabus. The topic was, germane to what was advertised, and they taught what was taught. So to me, that's basically a couple questions, maybe 2 or 3 that are just yes or no, and then beyond, because like these scales, and we could do Likert scales, but like the reality is, what are we doing if they check partially versus completely? What's our,
Right.
we're not. So I just think, the pragmatic way to look at these is that they serve somewhat as the audit more than quality. I mean, quality assurance in a big picture, but the reality is, for what we want is the attestation from the attendee that they actually, attended the course, and it was the time, and that the provider actually abided, by the hours that if they said, hey, this course runs from 8 to 2, and then somebody gets on there and goes, yeah, they didn't start till 9 and only went to 12. But so I think beyond just asking a couple quick questions to attest to the hours and the time, and then providing a link for any concerns or anything else that then can be sent to us with a little more detail as to the things that would have been maybe no answers, versus getting into where I could just see where the continuing ed competency is clear to you. I could just see that right now as half the people on there.
Absolutely.
That's more of a provider instructor maybe role. I think, the nuance of what that education competency might be might be confused with what the learning objectives and were they addressed, and these are just people getting continuing ed. So they could say, yeah, I knew what the learning objective was, or I knew kind of what the competency was, but like, was it adequately addressed? Well, I'm not a teacher, and I'm not an instructor, and I'm not, they taught it, and they taught. So I think the real issue for us is just to use it as the attestation of, what did it happen at this time, and was the subject matter, as advertised, etc. Those are kind of our major concerns. I think that the course actually happened, and it happened for the amount of time that they were required to be there. And then secondarily, we just simply, which shortens this up quite a bit. So it makes it very easy, which is also what I'm thinking too, is that we make this a lot easier on everybody, including the attendees and the instructors and our staff. And then secondarily, we provide a direct, another email link or something to say, if you have any concerns, comments, or suggestions about this course, send an email to this email, and just let them know. I do think that once we get into beyond the attestation, because the attestation should be I mean, we should know who's sending that in, right? Otherwise, what's the
What's the
what's the
point?
value? I don't really get it. I mean, other than, so I think the attestation, we should ask, like, okay, you're attesting that you were there at this day and time and the course was at advertising, what's your license number, blah, 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 blah. And then secondarily, beyond that, it's just really a matter of saying, okay, if you want to submit or just, comments or concerns about this course, then, off we go from there. And then we're only getting the things that are more meaningful to us, which are the concerns from the field or, things that
Yeah.
they didn't quite see as, and
I completely
that's
concur.
Great. So
I completely concur.
we're in agreement that the concerns are of course the biggest priority, and a link to enable them to elaborate on those and not just check a box is important still. I agree with that, as well as the attestation, of course. And any answers, any questions that did not meet the expectation or had further comments, concerns, or answered no to, was the course starting on time? What were the hours appropriate, and all of that should also be a part of that link. Any questions that you answered no to regarding the attestation could be further explained there. So that being said, do you see where we're going with that? Does staff see where we're going there? Or have any questions or comments?
No, I
Yes, I
understand where you're going.
Okay, that being said, that's looks like that is it for the discussion. On the discussion on item number 4. So this seems to be a duplicate. Again, we have a public comment section for agenda item number 5 for items not on the agenda.
Madam Chair, this is the moderator. Do we have to open for public comment for agenda item number 4?
Yes.
Would you like me to open that feature?
Yes, please.
This is the moderator, and at the direction of the committee, I have opened the Q&A panel. If you would like to request public comment, please click on the icon within this question mark within the square located in the lower right-hand portion of your screen and type, "I would like to make a comment." All other means of requesting public comments will not be addressed at this time. I will pause momentarily to allow individuals time to access this feature. Again, you will be provided 2 minutes and given a 15-second warning. With that, we do have an individual identified as Lori Eisenberg. Your microphone has been unmuted.
Hello? Am I on?
Yes, you are unmuted.
Oh, great. Hi, everybody. That's Lori Eisenberg from Life Chiropractic College West. Good discussion today, and I just wanted to let you know about the evaluations. It's very common among other state boards to require that seminar issue evaluations and gather them up. And then if the course is audited, then it's the provider's responsibility to give those evaluations to the board. And that feels like it's something that most people do, I hope most people do, and something that might be a more comfortable workload for everyone. I would also suggest that making the evaluations mandatory is very, very difficult, especially in large conferences. It's the kind of thing that's super hard to implement. For online courses, it's fine. And also, I would request that if we go this route, that individual providers be allowed to use their own survey integrating the questions that you have, because otherwise our people would have to fill out 2 different evaluations, because ours is much more substantive than the one that you've proposed, and it asks other questions in addition to the same questions that you ask. So those are my comments. I think the burden in terms of managing the process for having these sent to the board and making them mandatory might be just a little too much for most providers. Thanks.
At this time, there are no additional requests for public comment. Would you like me to close this feature?
Yes, please. Thank you.
You're very welcome. And Lori Eisenberg, if you could please lower your hand as well. This feature has been closed.
Moving on to agenda item number 5, which is public comment for items not on the agenda, which we have already addressed. Given that we've already addressed it, I would like to state that we will welcome comments at this time. Again, we will limit the comments this time to 1 minute, since this is a repeat of the same agenda item as earlier, and recognizing that adequate administration of time in the service of democratic distribution of time, so that we can hear perspectives that have not been heard before. At this time, moderator, if you would open that up again, I would appreciate that. Thank you.
You're very welcome. This is the moderator, and at the direction of the committee, I have opened the Q&A panel. Again, you will be provided 1 minute for your public comment and given a 15-second warning. With that, I will pause momentarily to allow individuals time to access this feature. It does not appear we've received any requests for public comment. Would you like me to close this feature?
Yes, please.
Feature has been closed.
Moving along, we're going to move to agenda item 6, future agenda items. The committee may not discuss or take action on any matter raised during this future agenda item section. This is not included, that are not included on our agenda, except to decide whether to place the matter on an agenda for a future meeting. Madam Moderator, would you please open up first? I'm sorry, let me ask if there are any future agenda items by board members or staff.
Yes, and I'm not sure if this is about future, but I think we should either discuss now or have on the future committee meeting some of the feedback that was provided to us from those meetings that the providers had. I attended one of those meetings, found it to be extremely helpful. I found the feedback that was forwarded from providers to the board that was then provided to us, that I reviewed, I think in the last, was it yesterday or the day before, to be extremely helpful. And I hope that we're going to circle back. I think we should, to, in light of some of that information, to the competencies and making them clearer for licensees as well as providers. And I think also of significance would be for the staff. I'm curious to get some feedback from the staff about, what input that they have relative to, not having good clarity on some of these competencies, and having examples and including specific examples on the competencies to give direction to providers. I think is certainly going to make it much easier on the staff. And that was one of the things that came up in the meeting that I attended, was making things clear, giving examples for the competencies, just so that the providers know what it is that the line of thinking was when these competencies were created. Having not been there when the competencies were created and put in place, and just kind of having attended these CE meetings now, getting a little bit clearer. I think that's good feedback that maybe we need to get a little bit more clear on them, and then give examples, which will then provide them direction, which will also in turn greatly help the staff when they're reviewing, these courses, and what competencies are being addressed, and making sure that, the staff making sure these competencies address what is being purported by the providers in certain sections. So, and also the feedback on the adjustive technique. I hope we can circle back to that and open that up for further discussion relative to being as not only in person but online. I thought one of the comments, I can't remember who said it, if it was Victor Tong, about that already right now technique can actually be done virtually, can be done by distance learning. So you can get your 4 hours of technique by distance learning, which means you're not even engaging in physical contact. So I think certainly making the fact that somebody has to look at a live presentation steps up that standard, certainly when we're thinking about safety and competency, to go from just doing technique on a distance learning format, like looking at slides on a PowerPoint, going to live interaction is a step up.
So
And
Larry,
also
we have to be
in person as well.
we have to be careful. This is for just discussing. We can't discuss any item that's not on the agenda. This is just to bring forth items that you want to see on the future agendas. So
Okay.
just listing those would be sufficient. We don't need
Sure.
to go into detail because this is not the appropriate time.
Yeah, that's what I'd like that. I'd like to circle back on some of those. So yeah, that's sufficient. Thank you.
Mm-hmm. And Dave or anyone else from staff?
I have nothing else. Thank you.
Thanks, Dr. Paris. That being said, at this time, we'll open this up to the public for to comment on future agenda items. However, again, as stated, future agenda items are just that. The committee may not discuss or take action on any matter raised during this future agenda items section that is not included already on this current agenda, except to decide whether or not we will place it on the future in a future meeting. So that being said, moderator, if you can open that up, and I'd like to limit that to 1 minute for anyone who has any comments, any public member with comments in this area.
This is the moderator, and at the direction of the committee, I have opened the Q&A panel. For your reference, being displayed on the screen are instructions on how to request public comment. With that, we do have an individual identified as Marcus Strutz. Again, you will be provided 1 minute and given a 15-second warning. Your microphone has been unmuted.
Hello, thank you for letting me talk. Yes, I was hoping a future agenda item could be revisiting of the technique being taught via Zoom. I've taken the time to put together an extensive survey, seeing over 1,400 DCs and 16 or 17 other providers, and the information is pretty clear that it should be allowed to be on Zoom. So it's a simple rewrite, shouldn't be a problem, but I would like that to be on a future agenda item. Thank you so much.
At this time, there are no additional requests for public comment. Would you like me to close this feature?
Yes, please close it. Thank you.
You're welcome. Feature has been closed.
That being said, that concludes all the business for today, and therefore at this time I'd like to adjourn the meeting. The time is 11:48 a.m. I'd like to thank everyone who participated today, thank the staff and the moderator for your tireless efforts and hard work in putting this together, and thank all the participants and especially the Continuing Ed Committee. Again, I'd like to adjourn the meeting, 11:49 a.m. Thank you.